Broadcast is now starting. All attendees are in listen-only mode.
Welcome to this webinar delivered by the ISM Trust. I'm Martin Pratt, a partner in the employment law team at Gordon Dadds. Before we begin, a few points. The content of this presentation is for information purposes only. It's not intended to be a substitute for legal or other professional advice and should not be relied upon as such. You can contact us about your specific situation, and ISM members can contact the ISM legal team. You can't see me, but you should be able to see the PowerPoint presentation displayed on your screen. You should also be able to hear me, but I can't hear you. If you experience any technical difficulties such as sound or quality issues, please let us know in the question box and we'll make attempts to resolve the issue. This webinar is being recorded and will be available to view on the ISM's website at ism.org/webinars. The law of employment relations is a bit stuck in the Victorian era. For many years and until quite recently, employees and employers in employment law situations were described as masters and servants. Things haven't really moved on, and the technology has moved ahead of the law. So recently we've had cases involving, for example, Uber drivers and plumbers with Pimlico Plumbers all bringing claims to challenge whether or not they're fully self-employed or are in fact employed under contracts of employment. Today at the Central London Employment Tribunal, my colleague at Gordon Dadds, Marie van der Zyl, is actually bringing a claim on behalf of a number of workers at the National Gallery who are having just these problems. They say they're employees, but the National Gallery disagrees. It's been in the news today, and it's good publicity for our firm, but hopefully we can give you some more practical advice today. So, the basics. There are, as you'll see on this slide, two things you can be. You can either be an employee or not employed. You can either be under a contract for service, which means you provide service to your employer, which until quite recently and in the Victorian era used to be called your master, or you can be under a contract for services, and that one letter at the end makes all the difference. If you're an employee, you are under a contract for service. You are under an obligation to provide your service to your employer. That means you do what you are told, and in return you get given regular work, and which you have to do personally. You can't send your mate along to your place of work to do it for you, to do your job for you. Employees always pay income tax and national insurance contributions deducted at source through the pay as you earn, or PAYE system. And depending on their individual circumstances, employees usually have nearly all of the employment law rights available, with a couple of exceptions, as we'll go on to see. However, if you work for yourself, essentially you can theoretically send a substitute to do the work for you. A good example of this is when you get a plumber in to fix your bathroom at home. He is not your employee because you can't tell him how to fix your bathroom, so long as at the end of the day the bathroom is properly fixed. And theoretically, he could send along his apprentice to do the job for him, so long as he does the job correctly and to your satisfaction. You don't have that level of control over your plumber. That's because the plumber is providing his work under a contract for services. If you are a self-employed person, you are responsible for your own tax affairs. It means usually you have to do a tax return, and you have very limited, if any, employment law rights under the relevant legislation. So let's talk very quickly about what indicators there are which would show that you are an employee rather than self-employed. Employees are under an obligation, and employers are also under an obligation to one another. It's called the wage work bargain. You provide your work as an employee, and in return you get wages or salary. You're under an obligation to make yourself available to do that work when you are asked to do it, and you will be given it on a regular basis. So you could be a part-time employee, but that's still regular. You can be a fixed-term employee for a period of time of up to, say, a year or perhaps longer, but you would still be required to make yourself available regularly to do the work on behalf of your employer. As I've mentioned previously, you can't send your mate Bob from down the pub to do your work for you. You can't send an apprentice along to do your work for you. You are personally responsible for doing your work when you're an employee. And you can't work anywhere else without permission. Now, if you're a part-time employee, you probably will have permission to work in other jobs during the days that you're not working, and that will likely be written into your employment contract. But if you're a full-time employee, it's very common to have express no moonlighting clauses in your employment contract if you have one. And even if you don't, then you are not allowed to work somewhere else where it could interfere with your employment. You will be paid at regular intervals if you're an employee. Now, that could be a fixed amount for a normal, salary, wages, for example. It might not be a fixed amount. It could be, you could be based on a commission rate, or agricultural workers sometimes do piecework based on the amount of produce they collect from fields, but it's normally a set amount, wages or salary. If you're an employee, you're normally integrated into a workforce. You have an actual job. I've put up on the slide there an example of an employment position in your field, musician at the Royal Opera House, section principal clarinet. That person has a job title, will be integrated into the orchestra at the Royal Opera House. Similarly, if you are, in my job, a solicitor in a law firm, or a partner in a law firm, you have a job title. You're integrated into the workforce. So that is another indicator of being an employee. You bear very little financial risk when you're an employee. You'll be paid come what may. Obviously, your employer might go bust. That's the risk that you have. You may lose your job. You may be made redundant, or if you behave particularly badly, you may be fired. But without those eventualities happening, you will be paid come what may. And you don't have to provide your own equipment. The plumber who comes to fix my bathroom will bring his own tools. If I employ a plumber if I'm rich enough to employ a plumber just to fix my house, he would expect me to provide him with tools. That's another indication of being an employee. So if you don't have those, are you self-employed? Well, you might be. If in your contract or in the terms that you verbally agreed, you have no obligation to accept work on offer. For example, you have a standing invitation to play at a certain venue, but you have conflicting appointments on that day and you can't make it, and you turn it down. That doesn't bring the relationship to an end. It's not something that you have to be, somewhere you have to be. You also have control over how you do the work. You can't be told how to play your instrument, obviously within reason. If somebody, if you turn up to asked to play jazz and you end up playing rock, that might cause difficulties. But if you are asked to play in a particular way on your instrument and you don't want to do that, you shouldn't have to. For example, to go back to my plumber, if he wants to use a particular tool to fix my sink, I can't tell him which tool to use so long as my sink is fixed. And now this isn't always true, but it's a very good indicator of self-employment, and one that the tax man takes particularly seriously. And that's, you have the right to send along somebody else to do your job if you want to. Now, in practice, that right is often fettered quite a lot, and the engaging party will say they want to be able to veto the person you propose to send along. But in principle, you should be able to send along your assistant to do the job instead of you on such a self-employed job. You can provide your services to whoever you like. That's key to self-employment status. It doesn't matter that, one club can't tell you not to perform in another club without a very good reason. The nature of the engagement, you'll be engaged for a specific project or a performance, and you won't be integrated into the workforce. Unlike the orchestra clarinetist in the previous slide, the piano tutor on this slide is not going to be integrated into the workforce. He or she will come and go as she pleases or as agreed to teach piano at the schools concerned. If anything goes wrong when you're self-employed, you bear that risk. You might personally go bankrupt because you have not got enough work in. You have a personal risk in doing this. So if you don't get the work in, so you simply don't get paid. That's the indicator of self-employment. And you should, if you are self-employed, provide your own equipment. Now, often some of these exist and some of them don't, these factors. And the law, in a kind of belated attempt to catch up with the 21st century and to look at how it can deal with what is now called the gig economy, has come up with a sort of intermediate status called worker. Now, Uber drivers, the Pimlico plumbers, Deliveroo riders, they've all had to do things and been under a level of control by Uber, Pimlico plumbers, which would have made them employees. For example, Uber drivers, had to do a certain amount of work in a certain amount of time. Pimlico plumbers, if you live in London, you will have seen their vans everywhere, and they had to wear a certain uniform. That showed a degree of control over those individuals. But Uber and Pimlico both said, no, you're not employees, you're self-employed. So when they went to the Employment Tribunal said, well, there are certain features of employment here and certain features of self-employment. What those individuals were was workers. Now, workers are a kind of halfway house between employee and pure self-employed. The good news is that they pay tax, as we'll see later, at the slightly more advantageous rate that self-employed people do. And the further good news is that they do pick up some, not all, but some of the rights that accrue to employees. They have much fewer rights than employees, but they have far more than somebody who is purely self-employed. Workers are people who are self-employed but agree to provide the work personally rather than within a group of companies, for example. And there are two very important reasons why you need to know whether you are an employee, a worker, or purely self-employed. The first is tax. HMRC, Her Majesty's Revenue and Customs, look at an individual's status in order to determine their liability to income tax or even VAT if they earn enough. Now, as I understand it, most musicians will need to register as self-employed, which means telling HMRC that you're a sole trader and you'll follow certain tax rules about recording your earnings and your expenses so that you pay the right amount of tax and avoid fines and possibly even prosecution. And it also matters because of your rights at work. Now, some of the core legal rights, that's most particularly the right not to be unfairly dismissed after 2 years and the right to receive a statutory redundancy payment, only apply to employees. They don't apply to workers. Workers do, however, have some really important protections that do apply to them. So they're entitled to the minimum wage. They're entitled to holiday under the working time regulations, paid holiday, even though, really confusingly, they're still regarded as self-employed for tax purposes. So if you're a worker and you've worked somewhere as a worker for 5 years or so, let's say, and you are dismissed, you don't have the right to bring a claim in unfair dismissal. However, if you haven't been paid holiday pay over that period, you may have rights to go back and say, hang on a minute, I haven't been paid holiday pay. I'm going to bring a claim for all that pay that I should have received every time I went off every summer. So let's take an example. Tackleford's a fictional place I've made up, so don't look for it on a map. But Ted Smith lives and works in Tackleford he's a church organist with the Diocese of Tackleford, and he provides services to churches within the diocese for, say, 20 hours a month, presumably mostly on Sundays. Ted's also a music teacher. He has his own small music school, and he works Tuesdays and Thursdays in the local schools for Tackleford Borough Council. Now, Ted has a contract with the diocese that says if he can't attend, then he needs to send somebody else or he won't get paid. However, they do provide him with paid holiday, and importantly, he's been given access to the diocese pension scheme. Now, I don't have Ted's contract with me, but if I were to take a guess, or a very educated guess, based on the facts that Ted has given me, he's probably a worker. He is self-employed. He pays tax on a self-employed basis, which means that he has to do a tax return every year and make sure that he does that without fail. But he gets some of the employment protections that accrue to employees, like the paid holiday that I mentioned, right not to be discriminated against, the right to minimum wage. Susan, on the other hand, is principal clarinet for the Tackleford Orchestra. Now, she only works 4 days a week, Tuesdays to Saturdays, but she's paid monthly through the orchestra's pay-as-you-earn system and has enrolled in its pension scheme. On Monday, she teaches in a local school. The orchestra said that they're fine with that. And she also occasionally helps up with her husband's music shop, where she's a shareholder on Sundays. Now, Susan gets paid holiday from the orchestra, but not from the school or from the music shop. In an example of how people can be more than one thing at once, Susan's an employee of the orchestra, but is purely self-employed when it comes to her teaching and her work in her husband's music shop. So if she fell out with her husband and was told not to come into the music shop anymore, she wouldn't have the right to bring an unfair dismissal claim. However, if she was unfairly sacked from the orchestra and she'd been there for 2 or more years, then she could bring a claim if she had been unfairly treated for unfair dismissal. So what rights do you get as an employee? Now, an employee will work to the terms of a contract of employment, and as I've said before, will carry out the work personally. Now, employees are entitled to get a written statement of their principal terms and conditions, which is usually in the form of an employment contract, but that might not be all of the employment contract, and there may be certain terms which are agreed through custom and practice or even orally with your employer. But a contract this principal statement of terms should set out terms like pay, annual leave, and working hours. Other things such as when you will be paid, the amount of holiday you get, and how discipline and grievance procedures are dealt with should also be dealt with in that principal terms, those principal terms in a contract. It is best to have it written down, but many people don't. So just because you don't have a written contract, don't discount the possibility that you might be an employee. You have the right to have such a written statement of employment, even if you don't actually have one. You can ask for one. You're also entitled to an itemized statement of what you're paid every week or every month. You're also entitled to be paid the national minimum wage. You get holiday pay for a minimum of 5.6 weeks per year. That can include bank holidays as well. That's 28 days if you're a full-time employee. And you will also get maternity pay, paternity pay, shared parental leave if it applies to you. You can request flexible working hours, for example, if you have childcare arrangements. It's a bit of a toothless rule, that one. It's very much just simply a right to request, but there is a penalty on the employer if they don't consider your request. You're not allowed to be discriminated against on the grounds of, for example, your sex, your sexual orientation, your ethnicity, your national background, your age, or your religious or philosophical beliefs. And after 2 years, you have the right not to be unfairly dismissed, and you will also receive a redundancy payment if you are made redundant after 2 years of employment. Workers, on the other hand, are generally have to carry out the work personally, but you may have a limited right to send somebody else. Workers, I'll give you some examples. They can include casual workers who come along as and when needed. That's 0 hours workers, people who are provided through an agency, freelance workers, seasonal workers. Those are all types of workers as opposed to employees, because they don't have the full indicators of what is and isn't an employee, but they have some of them. Workers are entitled to some employment rights, and those include the national minimum wage, holiday pay, protection against unlawful discrimination, and the right not to be treated less favourably than full-time workers if they work part-time. Now, if you're lucky enough to be completely self-employed, you are your own boss. You almost come and go as you please, as I say, and that means that you are not under the control of anybody, but equally you don't get the sort of parachute that employment law gives you. There are some things that some people can't do to you when you're self-employed. Obviously, you can't be forced to work in a place which is so dangerous that it's unsafe to work there. Your health and safety is still protected. And in fact, most cases, you'll be protected against unlawful discrimination. Your rights and responsibilities will be set out in the terms of the contract with your client. Now, employees, there are lots of implied things that comes out of the master and servant relationship that I was talking about earlier, such as the obligation to obey your employer's reasonable and lawful instructions. However, that doesn't necessarily apply to the completely self-employed. So the totality of their agreement will be set out in a preferably written contract with their clients. And in general, normally, if you take time off and you go away, you don't get paid. Tax, I think, is possibly the most important thing on a day-to-day basis, because get this wrong and serious things could happen. If you're self-employed, and I know that many musicians are, you are personally responsible for paying tax and national insurance on your income. So it's really important to stay on top of all your records to work out how much you need to pay and what expenses that you've paid that can be deducted. You pay income tax on your profits, not total income when you're self-employed, which is an advantage, which obviously means that it's to HMRC's advantage to sometimes try and establish that you are an employee in cases of doubt. Some of you may have heard of the IR35 regulations, which sort of show which are something which HMRC used to try and get the full amount of tax out of you on the basis that you should have been taxed as an employee rather than as self-employed. That's sometimes used. So, it's very important to get this right, so you can pay the correct national insurance contributions, which you need to do to get certain state benefits, including pension and universal credit. Given the problems surrounding getting this kind of thing wrong, it's strongly recommended to hire an experienced accountant to submit your tax returns for you every year. It's not something that I recommend you try and get wrong. You try and do yourself if you're in any way unsure about your correct status, or indeed how to complete the tax return. Some people, and I keep this brief because I know it's not true of many musicians, but some will set themselves up as a limited company. For example, some people have their own personal service companies. I don't have one, but I would perhaps set up Martin Pratt Limited, become the sole shareholder in Martin Pratt Limited, and pay myself dividends through that, which gives me certain protection, because if anything goes wrong, Martin Pratt Limited will be sued rather than Martin Pratt the person. You can set up your own business as a limited liability company, or even with others a limited liability partnership in order to do that. If you do, you'll have to pay corporation tax on your business profits as well as income tax on your own income. Again, you'll have to submit a self-assessment tax return for any money you earn through the company, and I strongly recommend that you hire an accountant to do this. So that's my spiel for today. I'm happy to take questions.
Okay, Martin, fantastic. That was really informative. We do have a few questions here. So one here, I am a music teacher. I've been working for a music service for the last 10 years. I'm part of a pool of teachers that the music service sends to schools within the borough to provide music lessons to school pupils. Over the last 5 years, I've been allocated to the same schools, which is 3 schools, and worked under the same timetable as a visiting music teacher. My pay rate has never been reviewed over all these years. The music service states that I am not an employee, but a casual worker, although I've never been given a contract. I receive holiday pay, but not pension contributions. What are my rights under this system? Am I an employee or a worker? Am I an employee or a worker of the service or the school? How can I improve my conditions of engagement?
Well, I think that you are probably engaged by the service. Whether or not you are an employee or a worker is a very interesting question, and I think that given what you've put here, there are arguments both ways. If I were acting for you, I would assert strongly that you are an employee, but I would get in touch with the ISM legal team regarding this, just so that they can look at the full details of your background to try and figure out what's what. There's a strong possibility that you are an employee. But again, it's not something I want to put the house on until a qualified lawyer or advisor has been able to listen to the full story.
Okay, thank you. Right, our next question. I've been told that for budget reasons, the school I work for as a visiting music teacher cannot keep me on their payroll. As a result, they stopped paying me holiday pay and pension contributions. I'm now asked to issue invoices for my work, and I have been sent a service agreement to sign. I have never been given any type of contract before. Nothing has changed in the nature of my work for the school though. I have always thought that I was an employee of the school. Now the school denies that I am an employee. What can I do to protect my rights?
Well, if this has all happened within the last 3 months, there are certain applications that you can bring in an employment tribunal. And again, I would advise you to go to the legal service regarding this. But if you were an employee and your contract has been brought to an end, that is a form of dismissal. And if you've been engaged for 2 or more years, you may be entitled to compensation for unfair dismissal and perhaps breach of contract as well. The time limits for bringing claims in the employment tribunal are very short. These days you have to go online to an organisation called ACAS, that's the Advisory Conciliation and Arbitration Service, and commence what's called early conciliation. If you Google or use your favourite search engine to put in ACAS early conciliation, and that will direct you to a page which allows you to start the process, and that will stop the 3-month time limit. I would advise talking to somebody at the legal service about the possibility of an unfair dismissal claim in these circumstances. But as I say, you need to get a move on to make sure that you do this within 3 months of things having changed.
Okay, thank you. Right, we have another question. I've been working for a school for 4 years as a music teacher on the basis of temporary part-time employment contracts for the length of 1 year. At the beginning of this academic year, I have been told that my fees will be reduced for budget reasons. I understand that part-time visiting music teachers are the only ones who have been affected by the cuts operated by the school. What can I do to protect my rights in these circumstances?
I think that there is a right under what's called the part-time workers regulations not to be treated unfavourably by virtue of your part-time status. It sounds like you may have a case there, and again, it is worth talking to the legal service about the potential of bringing such a case, remembering again, as with the last question, do move quickly because the time limit for bringing these claims is only 3 months. I would take legal advice before doing so, but from what you say there is a strong possibility that you have a claim.
Okay, thank you. Next one, I work as a visiting music teacher for 3 different schools on a self-employed basis. Last year I gave birth to my daughter and informed the schools that I would not work up until September 2018 due to maternity. When I contacted a school to rearrange my lessons, I found out that they had engaged another teacher instead of me, and there are no pupils that I can teach there. What can I do?
I think that the problem is that in a self-employed scenario, you don't have as extensive maternity rights as you would do if you were employed. Accordingly, I would talk to a legal advisor about the possibility of bringing a claim or a complaint relating to pregnancy and sex discrimination. Unfortunately, this is one of those circumstances where your employment rights are not as strong as they would have been had you been an employee, but you may be able to get some form of redress through the discrimination law, although from what you say, that may be difficult, but certainly worth talking to somebody about.
Okay, and we have another question here. I'm a self-employed choir leader with a national choir. We have to attend compulsory regular training days called meetings, which are unpaid and 3 times a year. These are for 3 days at a time, staying overnight. We are also told that we cannot work with any other similar choirs now until 2 years after we leave. It does very much feel like a master-servant operation much of the time, and yet we are self-employed. We have no real contract to speak of. I received one when I first joined 6 years ago, but it is very out of date. Perhaps we should be classed as workers, although we don't receive holiday pay. Just after your thoughts, please.
Yes, I agree that it does sound like you are a worker at the very least, possibly an employee, in which case it would be possible to press for holiday pay and national minimum wage, which means that if you have to attend work, you should be paid for it, and so these meetings should not be unpaid. Certainly something to look into. I agree. You may well be workers. You could even be employees. It is definitely something to investigate and perhaps raise with the choir itself.
Okay, thank you, Martin. Are there any other questions? Okay. I run a community choir. I've been interviewed and taken on by the choir committee. I am expected to take choir rehearsals on the same evening each week, all year round. I am expected to conduct all concert performances for which I am paid. The committee have input and the ultimate say on what music I teach to conduct. I have no contract and I assume that I'm self-employed. Is this right?
It's very difficult to say on that information, although I do think that if I had to take a position on this, you would be self-employed but classed as a worker, as I was explaining previously. I would advise very much talking to the legal team about this, because one evening a week, it may not be enough mutuality of obligation to make you an employee. Nevertheless, I do think that you should look into whether or not you're a worker, and if you're not getting all the rights that workers are entitled to assert those rights to the community choir. Thank you very much indeed for listening. I hope you found that informative. And again, if you have any other questions, the legal team at the ISM, I'm sure, would be happy to help. Thank you.
That was brilliant.